A very good morning to one and all. The speaker for today's session is about to join, and we'll start the session as soon as Madam joins. And I welcome you all for the session on IPR. So I welcome you, ma'am, and I thank you for accepting our invitation to be a part of this session on IPR. To all the participants who have joined for the session, let me introduce Dr. Thaorey, madam. She is working as an assistant professor at postgraduate teaching department of law, RTM Nagpur University. She has got over 12 years of work experience in the field of law. She has worked as in charge head of the department PGTD of law, ITMNE for 6 months. She has been awarded a PhD degree in the year 2008, and she has edited almost 5 books and have got almost 17 research articles in national and international journals. She has also quite a few number of conference proceedings and is very much active in helping us in formulation of the NISP, which is a part of IIC that has been put in place. Madam, I think you must have been updated about it, but the NISP document has been uploaded on the website, and the further process is in process. And we'll let you know for any more help that will be required in drafting of this particular policy. On behalf of Lakshminarayan Institute of Technology, madam, I thank you for being a part of this. Madam will be talking upon uh, different IPRs. What are those? What is the significance of all those IPRs, and how can we convert any process, or how can we safeguard how can we safeguard our idea, and if at all we have to use it, if anyone has to use it, how we are going to be benefited out of it. So, madam, I thank you, and I request you to please start your session. Thank you so much.
Okay, thank you. Thank you so much. I mean, I'm always happy to join LIT whenever it comes to IPR. So thanks once again. The topic which you have mentioned is quite big. Actually, it may not be possible to cover everything in 1 hour. But yes, I am going to discuss about the various components of IPR with which you can further study and discuss about how we can commercialize those and how we can utilize those in the our day-to-day lives. So let us begin. I hope my screen is visible to you. I have already tried. So today what we are going to discuss is about an introduction, or you can say the basics of IPR. Is my screen visible?
Yes, ma'am, it is visible.
Okay.
Yeah.
Now, basically, when we talk of intellectual property, always there is an anxiety about what actually it is or how we can call it as an intellectual property. But the thing is, to my understanding, today it is the board. You can really say what you can encash well. It is the only intellectual property which is there, and that's why it is very important, and particularly institutes like LIT, wherein lot of research and development activity goes on. I think each and every student must be aware about what intellectual wealth they are creating and how they can uh, protect that intellectual wealth in the form of intellectual property. So the concept of property is not new. We all are very much aware that there is property, and at times you often have come across the word that there is a movable property, immovable property, and in both the properties we try to create our own ownership. Like, for example, you are going to have your name on the property documents if you're buying any house or any car. So that name gives you the ownership because you have bought it. But what happened when something which is intangible, something which you cannot see, or something which you cannot feel, but that is the creation of your own mind, and if you want to prove that thing, then there is an issue that yes, I how can I am going to create a wealth or register a property which is intangible. So the classification of property is quite clear when it comes to ownership. One is movable, the another one is immovable, and then when it comes to intellectual property, we really talk about the tangible one and the intangible one. So basically what has happened, the claiming on property has been a part and parcel of our social life. And if we go back and see the formation of law, maybe from the uh, time when natural law theories prevail, or started explaining us about the creation of law, they all started with this notion that society is a contract, and we are here when one person saves the other and the other one saves the first one. So that's how we are here, and that is why every time, like, my family is my ownership, or my property is my ownership, my skill is my ownership, and if I want to be in this society, I need to see that my property is safeguarded from the other. So property concept is very old, and has a very ancient, or you can say a very early roots, wherein the whole civilization and transformation took place on the basis of this right to property, wherein it has been considered as more important than right to life. Yes, we had that time when right to property was more important. But what has happened with this, of course, growth of civilization, growth of science, technology, intellectual skills, creative writings, publication, and whatnot, okay, art, literature. So as this civilization started growing, we identified that this is not the regular property where it comes to skill-based learning, but it is something which is beyond that, and that needs to have a separate form of protection. See, otherwise the property law gets protection under Succession Act, under property laws, under the common law, which is there, tort law, which is there. But when it comes to intellectual property right, this is something different, because it is not as similar as that of movable and immovable property. And that is why the growth of science and technology and industrial growth, creative skill, makes it clear that a separate form of protection is required for intellectual property, which is not similar to that of the traditional mode of property which is there. And this is how this thing comes in, intellectual property comes in, because number one, it is the product of your mind. For example, writing a poem, okay, or poem, or writing a story, it's all a product of your mind, or creating a tune, a musical tune, or inventing a product, or inventing a process. Now this is all your product of mind, because you have the ability to think in that way. You have the ability wherein you have converted your idea into a product which can be seen or which can be felt, and that is why it is considered as product of mind, and that is why the word intellectual has been associated with it. Of course, inherently it is a very conservative concept. The idea behind intellectual property is always such that you are going to have a very monopolistic approach, wherein exclusivity is going to be cherished and nurtured, that you are the only one who can do that. So this is a very conservative concept, wherein prima facie, or we can say primarily, um, we think only about the creator and nobody else, that he or she is the one who is the creator, and that is why his or her right needs to be protected. What is happening to others, that's not the matter of IPR to think about. And that is why we always call it as a very conservative concept. For example, when we talk of human rights is very much inclusive. It thinks about each and every one who is there in this earth, whether it is flora, fauna, human beings, anything. But when it comes to IPR, it does not think about others, and that is why we call it as a very conservative concept. Of course, it is egalitarian and utilitarian, wherein whosoever does it will get it. There is no discrimination. For example, we don't have reservation in the allotment of copyright or grant of patent, or for that matter, grant of geographical indications. There is no reservation, there is no religion-based discrimination or caste-based policies. Nothing has been adopted. It is very, very egalitarian, equalitarian, that whosoever comes in will gets it. And utilitarian approach, this is something very, very crucial, that if any invention or any creation or any skill, if that is not of public use, then no intellectual property right will be granted. For example, when it comes to atomic energy, okay, of course it has its own benefits, but it has its own bane, and that is why no atomic energy related technology will be patented, because destruction is always, possibility of destruction is always there. And intellectual property works with egalitarian and utilitarian concept, wherein maximum benefit of maximum number of people can be seen and considered. Of course, it is a non-physical property which stems from and is identified as, and whole value is based upon some idea. So idea is the basic thing. So from where IPR originates, we can say that it originates from idea. But from where IPR gets protection, certainly not from idea, but from the expression of that idea. Means you need to convert your idea. Whatsoever you are thinking about creating a lot many technologies or devices or instrument, but you are not working on it. That is just an idea with you. But if someone else copies your idea and creates it, then that person becomes the uh, originator of that uh, uh, that instrument or that product or that item whatsoever has been created. So execution becomes very, very important. So it starts with an idea, and when the idea gets converted into an expression through an execution, then we can say that there exists a potential chance to get the intellectual property right. So certainly, basically IPR is, we can say, a property right which is given to a particular class of people who has gained that right against the competition. Means, for example, there are some researches which is going on in LIT, but you cannot deny with the fact that similar type of research is also being carried over other institute, maybe across India or across the globe. And everybody has an equal chance to get the patent or industrial design for it. But whosoever comes first, okay, he is going to sail through that competition, and that is why whosoever comes first will possess that right against the whole competition which is going on. See, we cannot restrict the research or development at any point of time, but at the same time, those who have done the invention or has some innovation or created something which is extremely original, or we can say absolute originality is there, then in that case his or her right needs to be protected, and there comes the intellectual property right. So you are standing at one side against the whole competition, wherein people are also working on that same research or same product or same item or same device, something like that. So basically, in a layman's language, if we want to say what intellectual property is, it is an right which has been given when an idea has been converted into an expression. So this is something, it is something you must get to see दिखाइए हमें क्या है, what is that device, show us. And when you can show that, then only we can say that yes, this is an expression of the idea which needs to be protected. See, it is essential to protect. As I have said, idea when converts into expression, then only intellectual property is created. Only expression without an original idea makes your case very weak. Only idea without any expression, you have absolutely no chance. But the like proper combination of idea executed through an expression will fetch you the intellectual property right. So prima facie ये दो चीजें होना बहुत ही जरूरी है when you think of that you are involving into something which is going to create an intellectual wealth for you. I mean, these two things are essential. Now, what exactly we mean by IPR? I mean, intellectual property, the uniform, or we can say international definition, which has been provided is through Article 2, Subclause 8 of the WIPO Convention, wherein it has been, in a simple words, it has been said that IP is a product of mind. So anything, whether it is an invention, literary work, artistic work, or symbols, or names, images, design used in commerce. Now, I want to underline this word, used in commerce. If something which is not commercially utilized, then there is a less chance to get an intellectual property right for it. So as sir was rightly saying, how you're going to utilize your invention, again, that's a big thing. Just by creating an invention will not help, but in order to get the protection for your invention, or to register your intellectual property, you need to see the commercial viability of it. If it is not commercial, then the chances are less that you may not get the desired intellectual property protection for it. So commercialization of all the intellectual property is must, because for example, if you register a patent, and if you get the grant of patent, and if you are not utilizing it for 3 years commercially, then the patent office, the controller, has the right to revoke your patent. I mean, uh, that's the discretionary power which has been given, because you cannot compress the development just by creating an invention and keeping it with you and not allowing others to use. So that is not possible. That is why every intellectual property is associated with the commercialization of the product of mind. So this is extremely important. It is tangible, and at times it is intangible as well. For example, the sound, if a person can sing in a specific way, so whenever he sings, only at that time that sound will come, otherwise there is no such sound. So this is intangible. Okay, you are creating, or for that matter, someone is uh, painting, and there are a number of ways in which nowadays we can see people are creating art. So that is intangible. Only when that person does that time only, otherwise we cannot imitate, or we cannot see what kind of work he is doing. So it is tangible as well as it is intangible. And of course, IP has a bigger domain, wherein a lot of employment is generated, consumer benefits, profits. I mean, uh, let us think about maybe 30 years back, India had only one or two types of two-wheelers, Bajaj and maybe Yamaha or something, but we did not have choice. Think about today. Today, the consumer is having a lot of choice. Not only which type, I mean, whether it is petrol one or electric one, whether auto start or not. So lots of features is there. So this is the benefit which the consumer is getting, depending upon his or her choice, and of course, which is suited to his or her budget. So a lot of choices has been given to the consumer, and of course, all these inventions dives towards earning profit to the institute. Like for example, you take any automobile, or let us talk about Reliance Jio. They are earning huge profit with the device invention. So likewise, lot of uh, IP works in creating economic infrastructure and financial opportunities for the people of the country and outside the country, and that is why it is extremely essential to not only promote but also protect the intellectual property, not only at the national level but of course at the international level as well. Um, what is the nature? Now this is actually very basics, but I think as a student you all should be aware about for what you are claiming for. You know, when we talk of intellectual property, one thing which is very clear that there is no material existence. Okay, you may get the grant in the form of one certificate which has been issued by IPO, or if I go beyond and talk about intellectual property in the form of copyright, there is absolutely no material existence. For example, the writings of Pula Deshpande, or his poems, or the plays, you know, which he has written. I mean, it is just that Pula Deshpande has written. There is no other material existence. And after his demise, there were a lot of cases wherein people were exploiting his writings, and then the court intervened and said the copyright posthumously belongs to him for 50 years in India. So for 50 years, no one can use Pula Deshpande's works after his demise. So there is, I think, still 40 years or maybe 35 years to go when we can use his work in public domain. So because there is no material existence. So another good example is geographical indication. You know, Nagpur oranges. I mean, anybody can grow Nagpur orange in Nagpur. So there is as such no material existence ki only I or only you can grow. So such type of complexity and you can say sensitivity is there when it comes to intellectual property. Of course, it has a cross-border effect. What uh, we are creating for, again, a good example is Nagpur oranges. Hardly we find oranges in Nagpur because all of them gets export. Similarly, Alfonso mango, nobody tastes at that place, you know, because everything gets exported. So it has got a very huge cross-border impact, something which is allowed or something which is not allowed. Okay, so that is there. When I say it is a negative right, basically it means that whenever an intellectual property right is granted, it has been granted to you. That means I have been in a position now that I should not infringe your right. So it is a negative right. जिसको दिया है वो उसके पास है, but दूसरों को ये खबरदारी रखनी है कि उनका right violate ना हो. It's a sui generis right, means the government on their own creates their own right. Basically, the rights which we give to plant varieties, patents, process patents, then identifying the new type of variety, agricultural process. So इसके लिए ना sui generis rights है, because I mean, I don't want to go into that discussion, but just to make you aware, we have been signatory to TRIPS, and under that, because we are part of WTO, we have signed the TRIPS document, and we have given an undertaking that we will follow the international norms. And internationally, there are a lot of relaxations, you know, which has been granted to various sort of intellectual property right when it comes to geographical indication, plant varieties, trade secrets, and later, once, I mean, after we surrendered to WTO, few years later we understood that we did a mistake, and now how to rectify it. So better way was just to make a provision under Article 20 of the TRIPS, wherein it has been allowed to make a sui generis law, that is laws on our own, wherein we can protect our own work, though it's kind of bypass road. It's not like we are going from the city, it's just like a bypass protection. So to GIs, to plant varieties, to traditional knowledge, we do give a sui generis right protection. um, all the intellectual property rights, they are moral rights first, and then they are legal rights, because you are the creator, and that is why you must get the protection. protection. So it's a moral right which has been converted via through some conventions and enactments and laws as a legal right. Okay, and it includes neighboring rights as well. For example, derivative rights. Of course, when we will discuss the various types of IPR, I am going to touch upon this issue as well. It supports research and development. Undoubtedly, it is a private right because it has been given to an individual person or group of people who have applied for it. It is not a general right. कि सबको दे दिया, ऐसे नहीं होता है. It balances the interest between creator and the society in an optimum manner. Because you are the creator, you get a patent and you can commercially exploit, you get commercial benefit, and that is why you want to make this thing available for the people. As I am, as an individual, I am not an inventor, but I want to use this invention or this product or this item, so I will get it from you. And that is why it is like a big or you can say the best way to balance the interest, between the two. And IPR is always progressive nowadays. I mean, in 2021, which is the most progressive nation or developed nation, is evaluated on the basis of how much patent it has registered. For example, countries like India, wherein we have very few, in hundreds, maybe like 1,200 or 1,300 patents we registered yearly. And if you see China or Japan, they registered in lakhs, 4 lakhs, 5 lakhs patents have been registered every year. So that's the difference. Of course, we it does not mean that we are not doing research, but we are somewhere lacking in awareness about how to protect our inventions. So probably in coming time, we can see a lot more patent protection, many of them from LIT, of course. So it's a very progressive thing, IPR. Now, this is something which I want to focus on. There are various components of IPR, okay? And the most decorated one is, of course, the patent, because everyone thinks patents are great, and then followed by copyright, trademark, industrial design, geographical indication, trade secrets and trade dress, and followed by traditional knowledge. We will go one by one. Of course, I may not be able to discuss each and every aspect of it, because patent itself will take probably 2 or 3 or 4 or 5 months. We cannot discuss them in one lecture. But yes, we can provide some insights wherein at least basic understanding is created about what do we understand by patents. Um, Basically, what happens now, you all are working, and many of you must be involved in a lot of research activities. So we in every research, we try to do something which is new, something which is unknown, something which is undisclosed. So far nobody else is in a position to think about it, and then you create that device. Or if there is some problem, for example, when electricity was uh, like invented, we were having a problem of darkness. So in order to come out of that particular problem of darkness, a technical solution was provided by way of creating electricity, and this is how the society gets benefited. So basically, patent is granted. I mean, it is always granted. See, patent, you never need to register. It is always granted. Granted means it is the government who is going to give you that grant. Okay, the government who is going to accept that, yes, you are the creator, and that is why we have granted you the patent. Patent means exclusive right. Okay, so basically what happens, patent means when you have done something which is new, when you have provided or offering a solution to a problem which is existing or persisting in the society, and then for your efforts, for your hard work, and for your intellectual skill, because you have created something which is very new and useful in the society, the patent has been granted by way of a sanctioning letter or a grant letter by the authorized person. In India, of course, it is the Intellectual Property Office, that is the IPO, who sanctioned this letter. So to get the patent, technical information about the invention needs to be disclosed to the public in a patent application. Now, this is something extremely important because as I have said, this is a moral right. And when it comes to morality, we have to see that no one, it should not be unfair to anyone. If I am the creator, then let this thing, everybody should accept that yes, I am the creator. So whenever you make a patent application as per the law, patent act provision, there is a requirement to disclose uh, procedure, the steps which you have followed to bring out this invention, and of course the objective and purpose and the way of functioning of that invention to the public disclosure. Because if anyone, there is a provision of pre-grant and post-grant opposition. So if anyone has that sort of pre-grant and post-grant opposition, then they will be in a position to make it clear to the IPO office that no, I am the one who is the original creator of this item or device, and not the other one who has filed for it. So on morality ground, this is required, that it has to be a fair one, and that is why this public disclosure is required. Now, another thing which is important for patent is that many a time students ask me this question, that I have published my research paper in a journal, now can I patent it? Then the answer is no, you cannot, because once you publish it in a journal, unless in a very exceptional cases, it is already in public domain, so anybody can use it and they can create a device on it. And that is why it's an advice, don't publish, because once you publish it, get perished. So better publish it in the patent document, whatever your researches you are doing. That is, of course, a disclosure to the public. At the same time, it is a secure disclosure, that even if someone copies, but your date of application remains before someone else is copying and creating a device. So first come first serve basis may your application is protected. So this type of publication you can use instead of publishing it in any research journal or any other journal. Wait till you get the patent and then publish it in a journal. Number two, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others. Now, underline this word, by others, means you are the sole exclusive owner of that patent. So, what are the rights of patentee? Patentee has every right wherein he can deny others who are commercially exploiting, or others who are licensing that invention, or others who are assigning that invention to others. So you have absolute right, wherein you can stop others from exploiting your work without your own permission. For example, in case of franchisee or in case of licensing, you give the permission, but otherwise you are the sole owner. So that protection is also secured, that others cannot intervene with your invention. Of course, it is a territorial right, number one, because you have to register the patent as per the law of the land. That is, for in India, we have to, if it is a patent under the Indian Patent Act, you have to register. But at the same time, that does not mean that you cannot seek an international protection for your patent. Of course, you can get this via the PCT, that is the Patent Cooperation Treaty. Internationally, you can register. At the same time, you can get an exclusive patent country wise. Like, for example, you want patent only in Japan or in Australia or in America, you can apply. But recently, the government of India has rejected the patent grant from Australia. So, if a patent is granted in Australia, you have to re-register that device or that invention in India, and you need to seek the Indian patent. Similarly, Americans, they have their own way of identifying I mean, their own criteria for grant of patent, which is not like India. So every country has different norms and different provisions and different procedures, and that is why country specific patent is desired. I mean, many a times it has been seen that lot of Indians, they file patents in America, but what is happening? Indian patents are reducing and American patents are rising because many of those patents are from India. So this happens, and it's permissible as well, because it is a territorial right, country specific right, and you have to take the patent as per the law of the country. So in India, we have the Patent Act 1970, which was amended in 2005, because we have been signatory to TRIPS, and a buffer period of 10 years was given to us from 1994, wherein it was directed that each and every member nation is going to amend their patent laws because of the fundamental principles of WTO, that is the most favored nation clause and the national treatment. So we have amended the laws, and um, now our laws, means that's probably one of the unfortunate thing we can say. Now our laws are very much internationally friendly, but they are not locally friendly, because we have been accommodative of the MOPEN clause, and that's why a lot many things are permitted to get the grant of patent, but at the same time not many things have been restricted. Just I was saying the Plant Varieties Act. Okay, so plant varieties is a restriction of the TRIPS norm, and that is why a sui generis protection has been mentioned, because anything which is natural, anything which is uh, related to living organism as per MFN and national treatment cannot be patented. But in India, because we are an agricultural country, we can see, after every 10 kilometers, there is a new variety of plant which is there that needs to be patented. So we have lot of sui generis laws, but yes, we have Patent Act 1970 amended in 2005, which is again amended. The most recent one is 2016, wherein related to environment, related to fees, and related to procedure, a lot of change has been made. So patents is the most decorated one, because the scope of protection which patent provides is vast. The tenure is only for 20 years, but the commercial gain within those 20 years is huge, because there is a criteria of patentable subject matter, wherein essentially three things are required. Number one, it has to be an invention involving an inventive step. Number two, it should not be something which is disclosed one. So non-obvious thing is required. It should not be very obvious that, oh, if this happens, then obviously this will happen. So it should not be a very obvious kind of thing. So it needs to be very non-obvious. For example, if there is rain, or if you put water and then the plant will grow, you cannot get the patent for this process, because this is a very obvious thing. This is obviously going to happen. So maybe in your research, I am not a science student, so I don't know, but there may be like one chemical creating a reaction on the other in some other form, which is very obvious, and this is going to happen. So for example, like this is the only thing which I know, H2 plus O is water. So that's an obvious combination. We cannot get a patent for it. So likewise, it has to be non-obvious. There has to be an invention. Again, I don't want to go into the details, but discovery and invention. Now, these are the two things which are different. If it is an discovery, no patent will be granted. But if it is an invention, patent will be granted. But discovery, when process related is there. For example, you have discovered the process of identifying a DNA sequence, then that is patented. So we have to, I mean, when you will be drafting your patent claim, you have to mention all these things. Which is there, but that needs to be explained in a very very precise and clear manner. So patent drafting becomes very very important. So these are the things which are completely regulated by the Indian Patent Act, wherein a patent grant is there for a term of 20 years, which you can renew also if there is no similar type of invention which has occurred during that place. Another feature or another component of intellectual property is copyright. Now, copyright is one which you and me as a teacher, we come across many times. All your dissertation, the thesis, the research paper which you are writing, they all gets a copyright. In your case, as a student, the copyright belongs to your institute, LIT. But when you get your degree and when you enter your professional life, and that time if you write something, then the copyright belongs to you. So basically, what is a copyright? It has been given, copyright is a right which is given on original work of authorship, including literary, dramatic, musical and artistic work, even computer software. Now this is the recent amendment in India. Computer software means writing the code is a part of copyright, but software, unless and until supported by an hardware, is not patented. For getting a patent on software, you need to come up with the hardware as well. So hardware followed by software, then patent. Only software is always a copyright in India. So any sort of work, for example, music or films or photographs or artifacts, anything which you are creating, then that will fall under the purview of copyright. Of course, there is an exception when it comes to academic and research work. You can refer the books of other authors, the researches done by other scientists and researchers. You can refer them, but the thing is, you need to acknowledge. Okay, acknowledgement is extremely essential. Otherwise, it will be considered as copyright violation. See, there just like patent may, there is a requirement that you have to apply for the grant of patent. You have to. Nobody else will come and give you, okay, this is your patent. No, you have to apply. But vice versa, in case of copyright, the moment you write it and make a public disclosure of it, you get the copyright. You say that I am a bathroom singer, no copyright. It has to be known to public that you are singing or you're writing a poem or you're creating a tune. That needs to be known to the public, and then only copyright persists. Otherwise, writing on your own and keeping in your cupboard or in your drawer will not fetch you any copyright. Number two, nowadays there is this thing of derivative work which I was talking about. For example, when the movie Bahubali becomes hit, automatically we see that after few days a Bahubali toy is coming in, and then after few days Bahubali comic come in, and now that character has been developed. So something which was not there in that movie, now even those stories are coming in. Okay? How Bahubali did this, how that, and Bahubali was in space and Bahubali was in universe, something like that. But all this is a derivative work which is created on one work, and that is Bahubali. And that is why the original creator will always have its own share when it comes to the copyright on those comics or on those toys or on those stories which have been part of Bahubali cartoon series or something like that. So that's a derivative work which needs to be considered. Or for example, making a play from the writings of Pula Deshpande. Now that's a derivative work. So that needs to be protected. So original author, he must get his own share. Or nowadays we have this trend of having a remix song. So remix is a derivative work. So for that also, the original author will have its own share in the profits and in the earnings of that work, unless that work is in public domain. For example, Mickey was registered in 1923 as a copyrighted thing. So maybe next year, 100 year after 100 year, Mickey will become up in public domain. So anyone across the world can use Mickey other than Disney. So this happens. So it has to be there in public work. Or another good example is using Ramayana or Mahabharata stories. Now we see there are thousands of versions of Ramayana and Mahabharata on television, on books, and different languages and different stories. So because Ramayana and Mahabharata is in public domain, there is no derivative work question. But if author, for example, Chetan Bhagat is writing a story and becoming a movie, then that's a derivative work. So that needs to be considered. So copyright has lot of new developments now, and as a researcher you should be well aware about where your copyright courses, because whatever writings you are doing for your research, that is a part and parcel of your copyrighted work, and that should not be used by someone else. So that needs to be taken into consideration. Registering a copyright is not a mandatory thing, but if you register, you have your own benefits. If you register your copyright, you can go to court, but if you don't register, then you cannot go to court. I mean, that's the thing. Unless there is any violation of your copyright wherein the other person is earning a lot of money on your name and on your fame. So that's the thing. It has been regulated through the Indian Copyright Act 1957, which has been amended many a time, 6 to 7 times so far it has been amended. The recent one was including copyright softwares as a part of copyright. Then the third one is the trademark. Now again, this is very interesting. What is the procedure to acquire a copyright? I will come back to this question maybe after I finish my talk. Yes, this is a trademark. Trademark basically means any mark which we have created to distinguish our service, goods or service of a particular enterprises from those of the others. For example, Haldiram, or you can see the name or the picture which I have used, a Maggie or McDonald's. So they basically represent the name and goodwill, and that is why this needs to be protected. Now I can if I see this logo of Maggie, I will not read the ingredient. If you see this logo, then those who are believers in Apple, they will not even think of the quality of it and they will buy that product. Same for Coca-Cola or any other. So lot of goodwill is there and consumer get attracted, and that is why this is important. Now imagine a world where there is no trademark. You are going to Haldiram, but Haldiram has no logo. Just imagine the situation, how it will look. I cannot even imagine. This will be very difficult to have a world wherein there is no trademark. Of course, trademark is different than a logo. Logo is something which is there for a particular product or a particular time, or wherein you can change it, as and when required. But when it comes to trademark, it's a brand. Okay, it has, there can be multiple logo inside a trademark. So that's the thing. Otherwise, sometimes we can say that the logo and trademark is the same, but trademark is quite a bigger concept as compared to logo, and you have to register. Okay, once you register your symbol or series of words, for example, if you see this Nike's, this just a correction, and we as a teacher probably we use this right mark thousands of times, but it has been copyrighted with Nike because they have used it in a very artistic manner, and that's why a trademark has been given to them. So combination of words, for example, Maggie, or just this symbol of M, if you see for McDonald's, that's something which has been trademarked. I mean, the protection has been provided that this is a mark, and there is no such tenure of trademark as long as it is there. Of course, after every 20 years you can renew it, and there is no denial of that renewal, because Haldiram belongs to Haldiram, so that trademark will be there. Whereas in case of patent, if there is a renewal, then whole process will go on, whether there is something new existing or better than this or not, commercial utilization, everything. In case of trademark, nothing will be seen. Again, in case of trademark, if your uh, mark is not so globally known, still also you can get the trademark. No need to make it recognized in like across the world. If it is very local, let us say Goli Vada Pav, it's a local thing. I mean, Ugre Vada Pav, local, they can have their own trademark as well. There is no such condition. The one which we have in patent is certainly not there in trademark. Trademark can be of different types: service mark, collective marks, artistic marks, and so many. You have to identify into which slot your mark is coming, and then you get your trademark registered. Again, the process is given under the Indian Trademark Act. The IPO office will register. If there is any objection, then that can be taken care, and you have to give explanation to those objection and clarification. And once everything sort out, your trademark is registered. The one thing which is an issue here is that like products means the same logo will be there, but the word will be MAGI, and when it is in city, still it is okay. But when you go to rural places, people are not able to read, or they don't even look into. Even if they see MAGI, they feel it is Maggie only because the packet looks same, the diagram, the color, the packaging, the dressing, everything looks the same, and that's where the problem is, and they buy that product. So Maggie is losing its business because of these type of like products, and that's the issue, which needs to be taken into consideration when it comes to registering your trademark, that you should not, neither you should violate someone else, nor someone else should violate your trademark. So that is something which needs to be taken into consideration. It is regulated through a common law remedy as well, that is called as passing off. Passing off means किसी ने मेरे जैसा यूज किया तो उसे हम उसने पास बाय किया है मेरे ट्रेड को, so we need to stop that person. So this is the passing off. And then this is industrial design, again something which will be used by lot many of you. It is a design, आप देख सकते हैं यहाँ पे the image wherein you are not creating the actual product, but you are creating various three-dimensional, nowadays even 4 or 5 dimensional designs for that particular article, or any instrument, or any machine or something, then that will get the patent. So whosoever designs it first will have again the first claim in patents as well. Okay, so designing, industrial designing also helps in getting the patent. So you can create this design, no need to go for invention. You can just sell off these designs to the manufacturing companies or to the manufacturing units, who are into it, and they will take your design, because you can sell those designs because your design is patented. Okay, so commercial use, commercial purposes के लिए you can always take the help of industrial designs. This has been regulated as a part of Designs Act 2000. Again, this is something which we created after the TRIPS agreement. Before 2000, we had patents में ही हम इसको protect करते थे, but now we have a separate act wherein designs patent have been granted. Registration of a design is a precondition for claiming any right related to design. So if your design is not registered, तो प्रॉब्लम है. रजिस्ट्रेशन के लिए फर्स्ट कम फर्स्ट सर्विस है, बट अगर आपने रजिस्टर ही नहीं किया है तो देन यू कैन नॉट क्लेम द moral element of it कि ये मैंने ही create किया है, because you have not registered. So registration of industrial design again is very very important for getting the industrial design protection. This is again very very interesting thing, geographical indication. We are blessed, Nagpur has a geographical indication in the form of Nagpur orange. So geographically that product is known, or this is basically something which is community benefit, which we can claim for intellectual property. So because of the weather condition, the climatic condition, the demographic features, Nagpur orange has a particular taste which is unique on its own way, and that's why a geographical indication is given. So basically, GI means an indication which identifies a good as an originating in the territory of a member. For example, Darjeeling tea, Banarsi sari, Kanjivaram sari, or Kashmir kesar. I mean, Bengal rasgulla. So these are the things, or Tirupati laddu. So these are the things which have got the GI tags. So GI is again, as I have mentioned, a sui generis act which is there because it was not mentioned in the TRIPS agreement. So in India, because there are number of people, wherein a lot of skill-based working is going on, whether it is weaving of silk or making of laddu or creating orange or so many, Puneri, Pagdi, all of them, they all come under GI tags. So that needs to be protected because this is the speciality. A lot of employment is there on the basis of Nagpur orange, or for that matter, Rasgulla. So a lot of employment. Though there is a tussle going on between Odisha and Bengal, that Rasgulla belongs to Bengal or Orissa. Some says Orissa, some says Bengal. So that is still going on because lot of variety of rasgullas are there, and some claim that few belongs to them and few belongs to them. So but place is important. Darjeeling tea naam se hi wo sell out ho jayega ki it is a Darjeeling tea. Or for that matter, the another one which is in line is Bhivapuri mirchi, which is near to Nagpur. That is also on its way to get the GI tag. And I think Nagpur Mosambhi is also now in process to get GI tags. So these are the things which are there, wherein lot of intellectual property is created. Again, this we created after we became party to TRIPS. Uske pehle to hamare paas ye bhi law nahi tha. So Geographical Indication Act 1999 talks about the protection of GIs in India. And this is a trade secret. This is another gray area, we can say, in the IPR. We have identified trade secrets as an IPR, but we don't have any specific law in India which regulates IPR, trade secret as an IPR. Countries like USA, they have laws on trade secrets. But in India, instead of using the word trade secret, we have identified the word confidential information. And we try to manage, it's like that something is better than nothing. So we identified it as a confidential information and try to protect it under the confidential information norm. But there is no such law which can protect trade secret. But trade secret is an intellectual property. For example, the formula of making Coca-Cola is a trade secret, and Coca-Cola is earning millions and millions, rather trillions of dollars on the basis of that formula only, and that's why it's the intellectual property. Or another thing, the fish medicine of Hyderabad, which is very famous, there is a trade secret on it. That organization does not want to share how the fish medicine is prepared, though it is very effective for, I think, taking care of asthma and other related diseases. I mean, that medicine is very useful, but they are having a trade secret on them wherein they are not allowing. So any sort of information, whether it is commercial, technical, negative information, scientific information, that is trade secret. Negative information in the sense, suppose if you are making a product, and if that product is not working, and you have noted down that because of these reasons this product does not work, and you are keeping that information only with you, it's a negative information and you can have a trade secret over it. Let others also try, let others also have their own share of losses. Why should we tell them that do not do this thing, if you do this thing the product fails? No, that's your work, you can keep it safe. So that's a negative information which you can keep and store as a trade secret. And lastly, there is this traditional knowledge which is there. And India, as I have told you, that we have a rich heritage, rich knowledge, rich what you can say, databases, which tells us that how rich we are when it comes to traditional knowledge. You all must be aware about the multi-million dollar cases of basmati rice, haldi, wherein our traditional knowledge were patented by foreign universities, and then we spent lakhs of rupees, I mean millions of rupees, to just claim that haldi belongs to our traditional knowledge. Similarly, we have been fighting cases for neem, abla, tulsi, adrak, and whatnot. And these are the things which are there in our day to day-to-day lives. We know them, but unfortunately we did not documented them. And till date, if you see, there is a good variety of herbal medicine. Now Ayush has started, I think, registering this, and we have this national traditional knowledge uh, um, uh, library and laboratory, wherein all this data has been collected. But unfortunately, we are still ignoring this part of intellectual property, and we are not aggressive enough, to protect this as an intellectual property. The very recent case I can tell you is uh, one German company got patent for making plates from the leaves of the tree. And how many of you have not seen, maybe in every function, we use that pattar, wherein we have our food on the leaves, and that is there since ages, and we all can make it. It's very simple. We have to just tie the small stick into different leaves, and we create that plate. But German got patented, and we did not, because we did not thought that it is a traditional knowledge which needs to be documented. And then now we will be spending millions of dollars just to say that this is something which is very common. We need to take some Purana Grantha and show that, see, this is written. But this is what is happening. We have been very ignorant about all this traditional knowledge. Lot of medicines, we have been very ignorant about making it documented, and that is why we are now suffering. Um, at least now we have started documenting. So maybe in another 10 or 20 years we can see that we have a huge database, wherein we can claim that the traditional knowledge is protected. Otherwise it is not. So basically traditional knowledge is something which is a knowledge or know-how, skills, practices that are developed, sustained, and passed from one generation to another within a community, often forming a part of its culture and spiritual identity. For example, Rajasthani dance, okay, it's a traditional knowledge which they know, or any type of recipe, or like cooking process. That's a very traditional thing which is there, and that has been carried on from generations to generation. But that needs to be documented, because this is uh, one of the most ignored, or you can say the vulnerable area, wherein others are claiming patents over this sort of traditional knowledge, and we are completely ignoring the potential of traditional knowledge. So that needs to be protected. In India, we don't have any law as such so far. We are very generous. Okay, we don't have any law for traditional knowledge. We believe in sharing, but now that sharing is uh, going to be reversed, because others are earning and we are losing. So this is the last part of it, traditional knowledge. So this is just, I just wanted to give you all a very brief idea about what exactly we understand by intellectual property rights. Of course, there are lot many things which you can study and discuss about intellectual property, and which all should know. We are having one workshop, 1 week workshop in RTMNU for discussing it in detail. If any of you are interested, you can join that workshop. If you have any queries, we can discuss it now.
Ma'am, I think Shripad has messaged you.
Yeah. What is the procedure to acquire a copyright for a software algorithm and models? Can we get a copyright for a code design on platforms like MATLAB and SPEN? The thing with copyright is, again, there is an IPO, Office Controller of Copyright. You can, Registrar of Copyright. You can just register it with them. Send your documents, they will verify and register. There will be some payment of fee. The procedure has been provided under the Copyright Act. Follow that procedure, and it is all online, so you don't need to go to office. Try to register. What about the code? They will examine, because I don't know, I'm not from science. I don't know whether MATLAB and Aspian, if they are open source, then then there is a problem. Okay, because if something, a derivative work, suppose if a derivative work which is done on an open source has a less chance to get copyright, or even if you get a copyright, maybe some share will be shared with MATLAB or SPED, so that needs to be looked into. So while making your application for registration, make sure that you are going to explain, because there is this case of Microsoft, wherein a code of 1500 lines was written, and when it was used by the other company, they claim that out of those 1500 lines, we copied only 10 or 20 lines. So if you see the ratio, hardly 1% or 2% the thing we copied. So can you say that we have violated the copyright? But the court in this case have very precisely mentioned this thing. If these 10 and 15 lines are the most essential lines of those softwares, then it is a copyright violation. Means if that's the, like बाकी का तो होता है ना, entry exit and how opening and closing of that software, that is common. But if there is some specific feature, for example lens cart mein, the software says that if you put this thing, then automatically your face will show that how will you look. So these few lines of that software are very important, and if someone copies that, then that is a copyright infringement. So that you have to convince that you are not copying the essential or core part of that software, but it's just a regular part which can be used, like it's general, then it is not a copyright violation.
Yeah. Actually, ma'am, most of the students are from final year and third year that are
Mhm,
amongst the participants. They are working on different ideas,
mhm.
and what mostly happens is for any kind of work, to have a patent, it has to be supported with some hardware. So if a particular work is regarding coding and we are trying to model a particular scenario, maybe it can be a new scenario or a different scenario. The question lies here that can we get a copyright for that? And of course, it will be done on these MATLAB and Aspen softwares are basically fundamental software based on which the entire computation happens.
That's the issue here, because as I understand, these are the open source code, right? MATLAB and SPEN,
Yes, yes,
and they
yes,
have been kept open for the people like who students who can use this thing and develop their ideas, and again that will be there in the open source, so that community learning will be there. So that's
right.
the thing, and that's why कहीं तो हमारा केस थोड़ा वीक हो जाता है यहाँ पे. बट इफ समथिंग विच इज extremely creative, which you are creating through this, then there is a chance that you will get a copyright.
And
Otherwise,
if we are talking about some kind of an hardware to be associated with a software, uh, is it the working software, working hardware, or it can be just a computer
it
or
has to be
any
working
HMI?
hardware, because then and then only you will be eligible to apply for patent. And in patentable subject matter is very important, because if it is not a if it does not suits the patentable subject matter category, then the hardware will not get patent. And if hardware does not get patent, then forget the question of getting patent, at least to softwares in India. Then again you have to go back to copyright, and if it is on like open source, again your case becomes more like vulnerable here, that you may not get even the copyright as well. So
Right.
that level of creativity needs to be uh, put forth in such a way. And that's why I mean the workshop which we are going to conduct, we are going to have exclusive lectures on how drafting should be there, or how you have to execute the patent filing process, so that less chances of getting it rejected. Because
Right.
lot many time you see more objections are there. I mean, firstly examiner ही objections उठाते कि ये आपका ओपन सोर्स में है तो नहीं होगा, फिर देन यू हैव टू एक्सप्लेन even if it is on open sourceware, but this is something which is new. No, even the creator of open source never thought of having this type of outcome from this software, and then probably you can justify that I will get a copyright. Otherwise, the case is very weak.
Right. Any more questions? The participants, if you have got any questions, you may please raise your hands and I'll unmute you. Maybe if you have got any specific questions, you can write down to us, and I'm sure Madam will be more than happy to guide us in all our patent related activities, because many students are actually working on very unique ideas, and
And that
as
is
a
why, means again
academician,
and again I am saying this thing, please attend that workshop. That has been
right?
exclusively meant for you, because this is such a vast topic. Now in 1 hour hardly we can
Exactly,
do any
exactly,
justice to this, and you all
exactly.
are working so hard, and we lack in patenting. I mean every year so much of research is going on in your institute or in any other research institute across our university, but we don't have patents for it because we are not aware about what will happen, if
Right,
I don't get it registered.
right,
So
right,
it's very very essential. And if you see, there are like half of the patents which has been granted is granted to the researchers, irrespective of whether they are students or their faculties. So it is
right.
it is it is your work, you must get it protected. I mean, अप्लाई तो करिए, ज्यादा से ज्यादा रिजेक्ट होगा ना, और क्या
Reject
होगा?
होगा.
I mean, that is how we have to
True.
look for it. That if you apply and if you get, you are in a better position. But if you apply and if you don't get patent, you are not going to lose anything. It's
Exactly,
as simple as
exactly.
that.
Right. Thank you so much, ma'am. Thank you so much for sparing time for us and guiding us about what IPRs are and how can we go about it. And also, we have also already disseminated the message of the workshop amongst the students. And I hope
It's
a few of the
there
students
in
who are
university announcement list. Maybe it is not scrolling yet. You have to just check down to the archives and you will find it.
sure, sure.
Please do register. It will really
I'll do that.
helpful for you all.
Thank you so much, ma'am. On behalf of Lakshminaran Institute of
Thank you.
Technology, I thank you.
Thank you.
And we are looking forward to more such sessions, more specific sessions on specific IPRs. And thank you so much, ma'am, for this.
Thank you.
Thank you.
Thank you. It's been a pleasure. Thank you so much.
Thank you.